Hi, my name is Ron Zambrano. I'm the Employment Law Chair here at West Coast Trial Lawyers, and I'm here to talk about a lot of steps that employers trip up on when dealing with employees. The most common mistake that I have found employers do is not understanding employee rights with regards to pregnancy leave. In California, there are two automatic sources of pregnancy leave and potentially a third one. The first one in California, applying to everybody but federal employees, is the Pregnancy Disability Act, PDL. That is an automatic 4 months for any employee that is pregnant, regardless of the amount of time they have worked. I'm going to repeat that. Automatic 4 months, regardless of how many days this person is working for you. So some people, if they work up until their due date, their 4 months starts then. Some people get, and it's happening more commonly now, especially with people waiting to get pregnant. A lot of people have high-risk pregnancies. They're 27 weeks, they're halfway in, and they need to take time off. That is not an FMLA leave. That is a pregnancy disability leave. And guess what? That is something the employer has to know. That's not something that has to be requested by the employee, other than the employee telling you, I'm pregnant, I need time off because of my pregnancy. That is it. Now, you can request that the OBGYN provide a certification, but that certification is not an FMLA certification necessarily. It is a pregnancy disability leave certification. Now, employers, if the employee says, my 4 months is up, but guess what? I want to exercise my rights under the FMLA. I want my additional 12 weeks if they qualify, right? The 1 year and the 1250 hours. They're entitled to that. Yes, you can get 4 months and 12 weeks of protected leave related to a pregnancy as long as a doctor certifies the FMLA leave. Now, this can be very burdensome for employers, but that's the way the law is written, and I believe that things can be framed either way. But yes, 7 months is possible. You could stack the 4 months under PDL with another 12 weeks of FMLA. In California, it's actually the CFRA, the California Family Rights Act. And your employee who had to carry a child, give birth to it, recover from that, and bond with that child is entitled to that leave. Now, what happens if after the 12 weeks, the employee goes, I have postpartum depression. I cannot return to work despite my 4 months plus 12 weeks. They are potentially covered under the Fair Employment and Housing Act as a disabled person, just like any other person with a mental condition that needs to be accommodated. A finite leave can be a reasonable accommodation even after we'll just estimate up to 7 months, okay? So please, employers, they trip up on this. They're like, no, it's only FMLA. No, you get FMLA leave. There's no, you get 12 weeks, and on the day after the 12 week, you have to, you're gonna be fired. That is not true. You get 4 months through PDL, person comes back, you gotta give them their job back, same position, and then they can stack it again with the FMLA leave, another 12 weeks. They come back within those 7 months of protected leave and their doctor certified it, they are automatically entitled to the prior position, prior pay, prior clients, prior schedule, prior everything. So please don't trip up on that. It's very important, and arguably we should treat mothers with a lot of respect because they go through a lot. So in my practice, the easiest cases I have is where the out-of-state company that employs people in California fire people as soon as their FMLA leave expires, right? So you have a sick employee, they qualify for FMLA, they get 12 weeks, and around around week 9 or 10, they give you certification going, I need an additional month off. I need an additional 6 weeks off, right? Now all of a sudden, they're above or beyond their 12-week FMLA protection. Out-of-state employers or out-of-state HR people with California employees look at this and go, well, the math is easy. You get 12 weeks. You want beyond that. We get to fire you. And then they just fire them for asking for more than 12 weeks. Well, guess what? Employers who do that violate the law. Well, how is that possible? Because there are two laws that run concurrently in California that protect a medical leave. Not only is it FMLA, which really is the California equivalent is really the CFRA, the California Family Rights Act. They're basically identical. On top of that is something called reasonable accommodation under the Fair Employment and Housing Act. So even though the 12 weeks has expired, an employer is still required to reasonably accommodate a disability, right? So for me, as a plaintiff's attorney who represents employees, I would make the argument, and typically it's a very strong argument, going, why couldn't you wait you've already waited 12 weeks, why can't you wait 2 more? So just wait 2 more. It is not an automatic in California that just because a leave is beyond 12 weeks, you get to fire that person. No, you have to do a case-by-case analysis under the Fair Employment and Housing Act of a reasonable accommodation. Now, if the person gives you a note going, I don't know when I'm gonna come back, it could be next week or next year, that is not a reasonable request for an accommodation. You probably would not be running afoul of the law under that circumstance, because you're not supposed to give an infinite leave, an infinite protection. That doesn't happen. But if the employee is giving a certification where these are finite leaves beyond the 12 weeks, you have to make an analysis of whether or not that is a hardship for you or not. So if you've already waited 12 and you want to fire them at 13, it's going to be a tough sell. It's going to be a very, very tough sell. So just be careful. Be careful. Out-of-state employers. FMLA is not the end-all be-all in California for medical leaves. Another category where employers kind of freak out and mess up on is when there's a complaint by an employee. Now, not every complaint raises the very scary head of a protected activity. Not every complaint raises everybody to be a whistleblower. Out of all the things that somebody can complain about, it's a very, very limited amount of categories that fall into quote unquote the protected class. Whistleblower is a catch-all one. It's Labor Code 1102.5, but just if somebody complains about an illegal activity, we are somebody selling guns out of the bathroom. Someone is, someone's dealing coke in the parking lot. These are illegal things, and if somebody complains about that this is happening in the workplace, that is a protected whistleblower. Okay, what happens if you have someone who is complaining about racism that they're overhearing? That is a protected activity. Once the complaint happens, a lot of employers are not sophisticated enough with a sophisticated HR system. A lot of mom and pop places don't know what to do. So the first thing you gotta do is do an investigation and put it in writing. Ask for information in writing. Interview, do it in writing. When you do the interview, make sure you either record it with someone's permission or you take contemporaneous notes. The last thing that an employer wants to do, and the best thing for me who represents employees, is when somebody tells me, oh yeah, we did a thorough investigation, but I have no documents about my thorough investigation of so many interviews, it didn't exist. It doesn't raise to the law. There is guidance from the EEOC about how to conduct an investigation. This is a cursory Google search. How to conduct an employee investigation. There's a list of what you should be doing. Just do it. But the first thing you gotta do is put it in writing, because if you don't put it in writing, somebody like me is gonna say it didn't happen and I'm halfway winning my battle, that you did not do a thorough investigation to address the complaint. Now, what happens when someone's complaining about sexual harassment? It's a very charged environment now. The Me Too movement is in full swing, which I personally believe is a good thing. So an employer should actually act reasonably when someone brings a complaint, whether the employer thinks it's true or not, of sexual harassment. 1, acknowledge it in writing. You've brought up a sexual harassment complaint against so-and-so. 2, separate the people. Separate the victim or the complainant and separate the person that is alleged to be the harasser. Do not keep them on the same shift. Don't do it. If you need to suspend somebody with or without pay, just do it. It is better to keep them separated and have people home than to have them continue working after you're on notice, because guess what? After you're on notice and someone again makes some stupid comment or look or laugh, the employer is now on the hook for the harassment, right? Because the employer thinks, this low-level person is acting a fool, and I don't have to do anything. This is this person's fault. Once you're on notice, that a low-level employee is harassing anybody, if that person harasses again, the employer is on the hook. The employer is on the hook. So just separate them out and then do your investigation. And make sure you do investigation fairly and with witnesses. Don't have one HR person with the complainant, one HR person with the alleged harasser. Make sure you have two people there. Make sure it's somehow memorialized contemporaneously, somebody typing furiously, or a recording with everybody's acknowledgement, so that later on it's not a he said, she said about what happened or didn't happen. And then act quickly. I have a case against a very, very large bank. Very large bank. It took 5 months and me getting involved from an allegation of rape to be investigated. Guess what I'm gonna do? I'm gonna make hay of that. So act quickly. It doesn't take a lot of time to go, we should separate these two. Within a week, you should start setting up interviews. Within 3 weeks, you should have some type of result in meetings, and then it is resolved. You don't have to be right as long as it's done in good faith. You don't have to be right. If it's a he said, she said thing, and you just happen to say, listen, I don't have anything to corroborate that the harasser did what you said they did, but look at how much I did. We'll try to keep you separated. You've done enough, okay? Do it in good faith, do it quickly, and keep documents. A very easy thing that people trip up on, employers trip up on, is how do wage and hour laws work in California? I'm sorry that you do business in California, and yes, there's very employee protect, is very employee friendly. Okay, so there's many, many different things, and these are the main ones that I always find that can cause a lot of headache for the employer. 1, meal and rest breaks. Okay, I recommend every employer to hire a third party to run your timekeeping so that they do the work for you. You are supposed to pay an employee an hour worth of work if they, 1, miss their lunch, or 2, start their lunch late. That means an extra hour every time that happens per day. They're supposed to clock out and they're supposed to clock in for their lunch. Now, I understand that sometimes employees do what they want. You can fire employees that constantly take lunches late, okay? If the employee consistently takes their lunches late, even though you telling them, don't do this because I have to pay you an hour, there's no reason for you to keep doing this, you can fire that person. But you have to still pay that person despite them not listening to you to take that lunch on time, okay? I'm assuming no employer is going out of their way to tell an employee, you cannot take your lunch on time, and no, I'm not gonna pay you the premium. You can't do that, okay? But please, tell your employees they're supposed to take it, and if they don't, you can punish them for it, but the punishment cannot be withholding the premium that they are owed. The second thing is this. An employer that asks an employee to come in and work their shift and tells them, I don't need you, you can go home, still owes that employee wages. It's called reporting time pay. You have to pay them either 2 hours or 4 hours depending on how their shifts work, but it's called reporting time pay. Please understand this. You have to pay them something because you've asked them to come in. The employee has taken your representation, employer, that they have work for that day, so they didn't go to look for somewhere else. You have to compensate them for that, okay? The other thing that's common misconception, that a lot of employers don't realize is when you ask an employee to drive from one location to the next location in their own car, you have to pay them for the use of that car, and you have to pay them for the time it takes it. Now, you can choose to actually pay drive time from location to location at minimum wage. So you can actually use 2 rates of pay in one day. Well, you're actually working at the location, let's pick a number, $25 an hour, but it takes an hour to get from one location to the next one, you can pay the minimum wage for that time, right? Because it's just not that productive for you. But you still have to compensate them for that. This is low-hanging fruit for people like me. My employer didn't pay me despite driving between places. I didn't get reimbursed for my cell phone while I'm in my car, while I'm being texted. You have to reimburse employees for the use of their phone that is work-related, and you have to reimburse employees for the use of their car that you're asking them to do in order to drop off money at the bank, to pick up stuff at Costco, to go to the post office, things like that. So that's low-hanging fruit for me. It's a very easy fix. It's not a lot of money. Just keep an eye on that and put everything in writing that you're requesting, and put it on your payroll, and make sure that when you pay these people this reimbursement money, that it's a separate line item. It's reimbursement for X. Thanks for watching. Like, comment, subscribe, and hit the bell in order to get more notifications.